I'm attorney Andrew Finkelstein, and today we're going to talk about the basics of injury law. There's a lot that you need to know that I hope today will answer many of those questions. First, the difference between injury law and criminal law, a lot of people don't realize. In criminal law, the purpose of criminal law is punishment and deterrence. The objective is to deter people from committing crimes. Well, that deterrence component also overrides in injury law. One of the important factors of injury law is to deter people from, frankly, doing stupid things. Because when people do stupid things and it hurts other people, that's bad, and they must be held accountable. Back to criminal law. With criminal law, the attorney that prosecutes, and that's what is called bringing a lawsuit, prosecution. The attorney that prosecutes a criminal case is the district attorney. In many areas, the district attorney is elected, and the district attorney has a group of lawyers who work with police agencies and prosecute criminals when they've committed a crime. Again, the purpose is to deter other people from violating the criminal procedural laws, and also to punish the wrongdoer for what they've done. With respect to injury law, when somebody does something stupid, and that's simply acting in a way that other reasonably prudent people would not act in the same or similar circumstance, they too must be held accountable. And the lawyers who prosecute people who engage in those types of activities are often called injury lawyers, personal injury lawyers, or accident lawyers. They prosecute people to seek two things. One is compensation for the person that they've harmed, the person they've done wrong to. And the second is overlaps from criminal law. It's also deterrence. We want people to act responsibly in everything they do. So there's a series of activities that people engage in that if they don't do it properly in the correct way, it could harm other people. One of the most obvious is driving a car, or maintaining your property, or manufacturing products. All of those activities must be done in a way that protects everybody in our community. If they fail to do it and somebody is harmed, then they are responsible for all of the damages that they cause. So, who is entitled to bring a personal injury lawsuit? Well, clearly, the person who is injured. Secondly, if they are married, their spouse can have a claim that is called a derivative claim. I'll talk about that in a moment. And sometimes, if there's a parent and no child, the child will have a loss of services claim. And lastly, if there's a wrongful death, when somebody is engaged in some activity or a business that results in the death of somebody, their estate and their loved ones can often bring a case. Now, the personal injury case has really many steps to it, but understanding what it is that people are responsible, the general term is negligence. And negligence has 4 different component parts to it. First is duty. Does an individual have a duty to act in a particular way or to do something? Do they have a responsibility? Responsibility and duty are interchangeable, that term. But does somebody have an obligation to do or act in a particular way? A simple example of duty often is in the medical field. A doctor has an obligation and or a duty to provide medical care in the same way that other physicians in that particular field, in that geography, also provides. Operating a car. When you drive a car, you have a duty to see that which there is to be seen and not hit pedestrians or other vehicles. You have a duty to keep that vehicle under reasonable control. When you own a property, you have an obligation, a responsibility, or a duty to keep it reasonably safe. Second, if you have a duty and you breach that duty, that is, that you fail to live up to your obligation, if you fail to do that which you are supposed to do, that is a breach. Now, oftentimes, what is misunderstood is simply because somebody has a duty, an obligation to act a particular way, and they breach that duty, they aren't automatically responsible because there's two other components to it. The breach of the duty must be what's termed as the proximate cause of the fourth factor, the injury. So if somebody has a duty, they breach that duty, the breach of that duty is the proximate cause of the injuries, then the individual or property owner or corporation is responsible for all of the damages that they've caused. Oftentimes, people can have a duty and breach their duty, but it causes no harm. A simple example is a operator of a car. They're driving and they're drunk and they're stopped at a red light. Well, they have a duty not to drive the car drunk. They've breached that duty because they're sitting in traffic drunk, but then they get hit in the rear. They've breached their duty, but it has caused no harm. The person who caused the harm is the vehicle that struck them in the rear. So there's no defense if you strike a drunk driver in the rear, an individual strikes a drunk driver in the rear. They had a duty, they breached it, and then they caused damages. Their defense cannot be, well, the operator of the car that we struck was drunk because they were negligent. That's true. But the negligence of the drunk driver did not cause any damage to anybody else. So those basic concepts of all four, duty, breach, proximate cause, and then damages, are the foundations of what are called a negligence case or an injury case. If you don't have all four of those elements, then a case will not be able to be sustained. Now, I'm going to move on to some specific scenarios related to duty, breach, causation, and damages. But before I do, I want to outline how these cases are actually discussed at court. At court, it's important to simply understand that at trial, a judge talks to a jury and asks a jury to answer those questions as to whether or not an individual breached a duty. What often is misunderstood is who is the deciding factor as to whether somebody is negligent and whether their negligence was a breach and that breach was the proximate cause of some damages. It's not a judge. It's not the lawyers. Ultimately, those are what are called questions of fact. It is a factual question as to whether or not somebody failed to live up to their obligations. Questions of law are limited to the judge. So typical questions of law are what law applies to a certain set of facts? What law? The question as to whether or not somebody violated the law are questions that jurors decide. So whether somebody was driving their car in a negligent manner, that being that they had a duty, they breached their duty, that breach was the proximate cause of the crash, and that crash was then the proximate cause of the injuries, those are all questions of fact for a jury to decide. Now, how does a jury know what to do? That's where the judge instructs the jury about what the law that applies. And the judge, I'm going to let you in on a little secret, doesn't memorize what all the law is. What the judge does is he pulls out his playbook. And his simple playbook is called the Pattern Jury Instructions. And there are many volumes of it. And what the judge really does is select which sections of law should be read to the jury, and in substance then ask the jury, did the person who is accused of causing the crash violate some section of law or standard, community standard, such that they should be held accountable for what they did? So the general charges, and that's what is a charge, is what is called the section that a judge reads to a jury, is often called a charge. The charges are very broad-based, and it's up to the jury to apply the facts of the case to the charge that the jury gives them. So a charge, as relates to negligence, is very broad. And the charge for negligence says simply this. First, the judge starts off by saying, members of the jury, we come now to the portion of the trial where you are instructed on the law applicable to the case, and then retire for your final deliberations. You have now heard all of the evidence introduced by the parties, and through arguments of their attorneys, you have learned the conclusions which each party believes you should be drawn from the evidence presented to you. In this case, you will decide only the question of fault, liability. That is, which party is responsible for the occurrence that brought these parties to court. Testimony or mention of any injury is not relevant. Now, the reason why I say that is because many jurisdictions have what is called a bifurcated trial. A bifurcated trial is where they take a trial and split it into two separate sections. The first section is related to fault. The second mini trial is related to injury and what's the extent of the injury. The reason why courts often will bifurcate a trial is because it accelerates the time frame for trials to move forward, because oftentimes the core dispute is who caused the event. It's often not in dispute, although many times it can be, but oftentimes once it's resolved who's responsible, the injury component can easily then be settled or resolved. So there'll be a lot of trials that are restricted and limited to fault. However, just because fault is decided doesn't mean that the case must settle. Oftentimes it will go on to a injury trial only. So when it's a liability or fault-based trial, the judge will read specifically, testimony or mention of any injury is not relevant, and if any person referred to injuries or medical treatment, I direct you to disregard it. You are being called upon to decide only the question of negligence or fault. This procedure is being followed by my direction, and no conclusion should be drawn against any party from that fact. The reason why the judge wants to restrict and limit any discussion about injuries in a fault trial is because it's not relevant. Who was injured as a result is not relevant as to how the event happened or who's responsible for it. So the judge tries to limit that type of information to the jury. The judge will then go on to read Burden of proof. Now, you may have heard beyond a reasonable doubt. Beyond a reasonable doubt is the standard and burden of proof when we are taking away somebody's liberties. It is the highest standard because to imprison somebody and take away their liberties, a jury must determine beyond a reasonable doubt that that individual did it. But when we're talking about an injury case, the standard is much lower and the burden of proof is much lower. The reason being is the goal and objective of injury law is twofold: to compensate the individual, but to also deter bad activities in the future. And our community and our society has decided that the burden to show that somebody else is cause of an event is lower because we're not taking anybody's liberties away, and we want to promote well-being within our community and that people will act properly, knowing that the standards to hold them accountable are lower than a criminal case. And lastly, the objective is to compensate somebody. We don't want to set such high burdens for somebody to be compensated when they've been injured through no fault of their own. We want it to be relatively easier for them to receive compensation than if we're putting somebody in jail. So the judge will go on to read what the burden of proof is in a civil case. A civil case, again, is not a criminal case. And the judge will go on to read, to say that a party has the burden of proof on a particular issue means that considering all the evidence in the case, the party's claim on that issue must be established by a fair preponderance of the credible evidence. So a fair preponderance of the credible evidence means the testimony or exhibits that you find worthy of belief. A preponderance means the greater part of the evidence. That does not mean the greater number of witnesses or the greater length of time taken by either side. The phrase preponderance of the evidence refers to the quality of the evidence, its weight, and the effect that it has on your minds. In order for a party to prevail on an issue on which he or she has the burden of proof, the evidence that supports his or her claims on the issue must appeal to you as more nearly representing what happened than the evidence opposed to it. If it does not, or if it weighs so evenly that you are unable to say that there is a preponderance of either side, you must decide the question against the party who has the burden of proof in favor of the opposing party. Now, I read that because that's exactly what the judge reads to a jury, and frankly, it's a little confusing. A lot of people don't understand the burden of proof because all it is, and if it's the scales of justice, and when the scales of justice tip ever so slightly, just a little bit in one party's favor or the other, at that point in time in a civil case, an injury case, the party who tipped the scales ever so slightly wins. It's like an election. When we elect a governor of the state, and if there are 1 million people who vote, 499,000 people can vote for one candidate, and 501,000 vote for the other candidate. The one candidate tipped the scales ever so slightly, but what happens is he's the governor of the entire state, or she's the governor of the entire state. It need not be 999,000 to 1, which is beyond a reasonable doubt. It only has to tip the scales ever so slightly. And that's what the burden of proof is in a civil case. Oftentimes people think, oh, he's guilty. Well, guilty is a phrase and a term really restricted to criminal matters. Guilt is when somebody has committed a crime and they violated the law. in negligence and injury cases, it's not considered guilt or not guilt. It's were they liable. Another phrase you may hear is were they culpable? Did they act in a way they should not have acted? That's all it is. It's liability. Fault. Were they responsible? Now, fault, the significant difference between criminal cases and civil cases and injury cases, the core distinction is intent. Oftentimes, in criminal cases, they must show the person intended the action to violate the crime. In civil cases, intent is not a factor. In fact, intent is the opposite of what happens in criminal cases. These are, and I'm reluctant to use the term accident, because accidents are when something was not foreseeable and we had no idea it might happen. So, for example, an infant sitting in a high chair that has a bowl of food, the infant doesn't know when they flail their arms around that the bowl of food will spill. But adults do. Adults know that if they don't act appropriately, and the hypothetical simply being if you're sitting at a restaurant and you have hot coffee sitting in front of you and you flail your arms around and strike the coffee, you know that that is going to likely lead to that coffee spilling and possibly someone being hurt. I don't define that as an accident. I define that as a preventable event, because what we handle as injury attorneys are preventable events. Every single time somebody gets hurt through the fault of somebody else failing to act appropriately, we can always point to what they should have done differently. And had they thought about it before they undertook that action, the event would have been prevented. Because each one of these events are foreseeable, and when they're foreseeable, they're preventable. So, moving back to the burden of proof, the burden of proof requires simply a finding that it was more likely than not that the individual undertook those particular actions, and that is the finding against the party. And that's, in law, we don't define individuals, we define them as parties. A party can be an individual, it could be a corporation, it could be the government, it could be your county government, a party to a lawsuit. Now, in injury law, once a party has met their burden of proof on the issues that they have the burden, the obligation to prove, then it's left to a jury to decide whether or not they believe that individual or the party who's brought the case. If they do agree that the party was negligent, that they acted in a way that was not consistent with what the laws require, they then will find liability. Now, in many states, it's not all or none. There can be multiple causes to an event. And just because there are multiple causes to an event does not mean that people can be shielded because somebody else may have also contributed to that event, including the injured person. An injured person is, and depending on the state, which I'll define in a moment, is entitled to recover for all of their damages caused by somebody else or another entity, and they are not allowed to recover for those portions that they are responsible for. So, for example, it's called contributory negligence. If the injured party contributed to the underlying event and causing of the underlying event, then that portion that they contributed gets deducted from any verdict or award that they recover. So as an illustration, and I'll draw this out for you, if somebody is crossing, let's say there's a pedestrian crossing a street, and the law says that they are required to cross in a marked crosswalk. However, at the intersecting street where they want to cross, there is no marked crosswalk. Well, the vehicle and traffic law defines where that marked crosswalk would be, and they should cross in that area. And a vehicle is driving down the road and strikes a pedestrian who the pedestrian believes is in the what would be the marked crosswalk. It's technically an unmarked crosswalk if there are no lines there. Well, the operator or driver of the car who struck the pedestrian says they were not in a marked crosswalk. In fact, they walked out from between two parked cars. That's the question of fact as to where was it that the crash occurred, and did it actually happen in the crosswalk or not in the crosswalk? Well, if a jury determines that the pedestrian is 20% responsible for being hit by the vehicle and the driver of the vehicle is 80% responsible, then the injured pedestrian is entitled to recover 80% of their full damages. A jury is then asked to render a verdict for the full amount of damages, and a judge, after the verdict is issued, reduces that total amount by 20%, which is called the 20% comparative fault that the injured person had. Now, some states have what is called pure comparative. Pure comparative is that if the injured individual is at fault at all, even 1%, they can't recover at all. Other states have a modified comparative, which says that if the injured individual is more than 50% at fault, then they are not entitled to recover. So if they are 49%, the injured individual is 49% at fault or less, they can recover for whatever that amount is, less their contributed fault. If they're more than 50%, then they can't recover anything. And then there are other states that are pure comparative, which basically says any portion, you can be 90% responsible. The injured individual can be 90% responsible and still recover the 10% of loss and damages that were caused by the other side. So that's the basic elements and concepts of injury law. I'll speak on other videos, and I hope you join me with those.